So, hello everyone. Good morning, good afternoon. Who are joining from US and Canada. Namaste everyone from people joining from India. This is Sagar, your host with another interesting topic on IPR trends for startups and budding attorneys. Today we'll be diving into exciting world of intellectual property right, IPR, and exploring the latest trends that are impacting startups and shaping the career of budding attorneys. For the Zoom attendees, we encourage you to use Q&A function in the Zoom interaction and to ask questions throughout the presentation. We'll address them during the designated Q&A segment at the end. This session is being recorded and will be shared with all registrants after this event. You can submit your question in the comment section for the LinkedIn Live audience. We appreciate your patience and understanding as we manage the Q&A. Thank you for joining us. Now let me introduce the moderator for today's session. We have with us Arvinder Singh, Senior Vice President, IP Solutions at Draft and Craft. Arvinder is a seasoned professional with a distinguished career spanning over 2 decades, characterized by expertise in IP sales within the realm of SaaS and services, operation management and quality control, with a comprehensive understanding and experience in management of various IP portfolios. Arvinder has consistently demonstrated a proven track record in overseeing process, optimizing workflow, and fostering a collaborative team environment. Based in Canada, Arvinder extends his influence beyond borders, frequently traveling to the United States, where he adeptly represents Draft and Craft. Over to you, Arvinder. Thank you.
Thank you so much, Sagar, for this wonderful introduction. All right. Let me first take this opportunity to introduce my panelists from the discussion today. We have Kevin Murphy with us today. He's a partner at Wush and Jering. So Kevin is a trial lawyer, and his areas of specialty is international commercial and intellectual property litigation. He's represented global companies in a variety of litigation, including patents, trade secrets, trademarks, copyright disputes, and he has successfully tried dozens of cases to verdict. He's also an avid speaker and has addressed the Indo-American Chamber of Commerce on Hatch-Waxman patent litigation and the inter-parties review process at the 13th annual IPR conference, which was held in Ahmedabad, India. Before his current assignment, Kevin has worked with various law firms in the New York area as a litigator, and is proud to serve as a prosecutor in the Manhattan District Attorney's Office. Thank you. Next, we have Raymond Urtiga from Patent Excel. Raymond was born in Peru and moved to the US with his family when he was 15 and settled around the New York City area. He adapted quickly to the new country, language, culture. Raymond did his bachelor's in mechanical engineering with honors, and he soon started working for Procter & Gamble in Cincinnati. He was not satisfied with his education, so he did his master's in business administration and took his law degree, both which he earned with honors. For past 2 decades, Raymond is an IP attorney combining his technical, business, and legal background. He's protecting his clients' inventions, brands, defending them against any kind of infringements as well. Raymond led an in-house team of lawyers that secured a win before the Supreme Court of the United States, in a case that has become a landmark case in patent law, is often cited in litigation involving patents. So we would definitely want to hear more about that later in our discussion today, Raymond. All right, last but not least, we have Rick Martin from Martin IP Law Group. As a kid, Rick loved to tear apart things to actually see how they were working. A skill which he acquired as a kid is now helping inventors who need someone to figuratively tear apart their invention and put words in which the US Patent and Trademark Office understands. Now, he knows a lot about USPTO because he has worked there as an examiner. Now, this insider knowledge, combined with his experience securing hundreds of patents across diverse fields make Rick an invaluable resource for anyone seeking to protect their innovations. He holds a bachelor's degree in industrial engineering, and he's done his JD from the Washington, D.C. After working for large law firms in Texas, Rick founded Martin IP Law Group in 2016. And as a dedicated intellectual property attorney, so he specializes in all the fields of IP, patents, trademark, copyrights, trade secret protection. So I welcome all my panelists today. Okay, let's start the discussion today. So just a little background. In 2023, a record-breaking 5.5 million new businesses were launched in the United States alone. Now, this is clearly reflecting a robust commercial spirit with an increased focus on technological advancements and creativity. Now, this surge has made the startups realize that protecting the unique invention and brands is much more critical than ever before. Now, if they have to sustain the growth and secure a competitive edge in the market. Now, this can clearly be seen in the US PTO data for filings for the last 3 years as well. Small entity patent filings in 2020, there were 28,900 new patent applications filed by small entities, which has increased to 32,800 by 2022, a significant 14% rise. Similar trends can be seen for trademark filings as well for small entities. In 2020, there were 95,000 trademarks applications which were filed, which increased to 101,000 by the year 2022. So with that background in mind, this leads me to my first question. And Kevin, this is for you. With all your experience, can you talk about some of the fundamental steps startups should take to first identify and then protect their intellectual property? So maybe some of the typical challenges for startups.
I do. The typical challenge for startup is usually funding. The main issue is learning what's possible to do with your IP. So most startups generally start in the trademark space in order to generate revenue if they have a product. Patent prosecution is very expensive and can be time-consuming, taking multiple rounds with the U.S. Patent and Trademark Office. Trademarks are a lot easier to secure. So most startups that I've dealt with usually is in the area of securing the appropriate trademark and doing so as quickly and as easily as possible. If you have a specific invention that you have in mind and you have funding, then it's appropriate to proceed to a patent prosecution situation. I would say this, that startups are in a very difficult position, and lawyers who are taking on that work are very interested in helping them, not for just the initial stages, but over the long haul. So negotiate for yourself a flat fee for both trademarks as well as patent prosecution. The attorneys will absolutely be interested in entering into those agreements with you because they understand the situation and they want a relationship, not just a few transactions.
Okay, all right, thank you. Raymond, would you want to add something on that?
Sure. Another challenge that I see, and this applies to a lot of small inventors, a lot of small entrepreneurs that are in the startup phase, is they simply lack the knowledge about IP and they put IP in the back burner. Yeah, eventually I'll get to it. But in the process, until they get to that point, they tend to make a lot of mistakes. And those mistakes, for example, may be in the form of disclosures of what they have in a non-confidential manner, which then later on, when they involve an attorney, and the attorney, one of the questions that he or she is going to ask is going to be, have you disclosed this to the public? And once they realize that the disclosure has been made, the bad news is, unfortunately, they may be out of any options, with some exceptions. I mean, if it's within the US and if it's within a certain time period, normally 1 year grace period, okay, maybe you'd be able to get a patent in the US, but that doesn't hold true for the great majority of countries throughout the world. So the lack of knowledge and the idea that, okay, I will spend some money, allocate some money to an IP attorney, and I'll do it later once I get fully funded is a mistake. And it's something that I see a lot.
Okay. All right. Thank you. Rick, do you see any more challenges apart from
I would kind of concur with that. And again, I think the most important thing to do as a startup company is at least allocate some funding to consult with an IP attorney to at least make you aware of what your potential rights are, to identify the IP you have, and to let you know things like deadlines to file, or you lose your possible opportunity to protect that. One of and I agree with Kevin. Trademarks are usually a good place to start, or that's usually where people do start because it's more cost effective. You can secure your trademark registrations for relatively small amount of money compared to what it's going to cost to secure patent protection. But if you really think about it, and again, you may or may not have things that need to be patented yet, but those disclosure concerns are real. And that if you don't file for your patent protection, but you move forward with a public disclosure or use or sale of something that's covered by the patent, those rights may vanish. They may disappear because you didn't take action in a timely manner. Whereas with a trademark, you're acquiring at least some limited protection just by using the name, using the logo, using the slogan. It may box you in by not seeking federal protection early on, but at least you have some limited protection. So, there's really a lot going on and a lot of moving parts to IP, and I think it's really critical to seek expert help early on and identify what are the more critical things to protect now and what can wait until later, because if you don't do that, you're probably going to miss something important on the front end.
Yeah, absolutely. And I think the
additional,
data is also, sorry, Raymond, go ahead.
well, I was going to say, no, and yet one additional point, and something that is overlooked often, is the area of trade secrets. An IT attorney that you hire early on in the process can actually help you, guide you, set up some communication protocols and other measures that you should take right from the beginning, just to protect anything that eventually will not end up in a patent because maybe it's not patentable, maybe it's software related, and therefore it's something that you eventually will want to keep as a trade secret. And if later on you're in litigation and it is then your burden to show that you kept something you considered as trade secret and you didn't take those measures right off the bat, right from the start, then you will not meet that burden and you're going to lose if eventually that information leaks out.
Yeah, yeah, and I think that is something we might be discussing later in the webinar. And I agree with both Rick and Kevin about filing more trademarks, and that is very evident with the data as well. So with the small entities, if you see there were in comparison to the patents, trademarks is 3 times more than what the patents have been filed in the USPTO. Yep, so I agree. So Raymond, you talked about having the knowledge of IP, and that's something where the startups are lacking, and I think because there's so much happening in IP these days, what do you suggest? What's a starting point for startups or budding attorneys to stay informed about the ever evolving IP trends, legislations, everything around it?
There's a lot of, well, stay informed. That is the underlying message. Just stay informed. But how do you go about staying informed? Do I need to spend a lot of money? The reality is, no, not necessarily. There are really, really good blogs out there that are dedicated to intellectual property, patents, trademarks, etc., and they are free of charge. You can subscribe to them, and they keep up. There are people that do this almost full time, where they keep up with all the case law in the U.S. That is very important because that is the name of the game. It's case law, and not necessarily in other countries where it's all based on the code. But the case law, I have a hard time keeping up with it. But I have I have no choice. I have to read those blogs, and if something sparks my interest, then do a little bit of research myself, maybe go to the actual opinion from that was being discussed. So bottom line, stay informed, stay educated. And if you're a startup, and if you do what Rick suggested, which is allocate a little bit of money to have some IPR person to help you, maybe that person can help you just informally, keeping you informed. And we do that all the time, sending our clients information on new developments of the law or watch outs that they need to pay attention to. And there's no reason why that should cost much money.
Rick, I've seen, and USPTO is an example where any information regarding IP, it's all there. So do you suggest that the startups should use USPTO as a Bible for everything?
I wouldn't necessarily say as a Bible, but it's a good place to start. I mean, it's they do put out a lot of information. They do put out a lot of publications. Anytime there's changes in the law or things going on, they've been very, very good about tracking a lot of the AI stuff and how that relates to IP here lately. So it's one good resource, and I would say that yes, that's definitely one you should keep up with. But again, there are blogs out there. The AIPLA is another organization that puts out a lot of content that you can follow and use to kind of keep up with current trends and what's going on. And again, I think those are good resources for attorneys. For the startups themselves, I think some of the one, it may be difficult to understand and comprehend if you don't have the basic knowledge already there to understand, the rules of the game and what's going on. So I still think it's beneficial for, the startup companies themselves to allocate some resources upfront early on to consult with an IP attorney or an expert in IP to kind of guide them and direct them. Because, again, the attorney's going to be up to date on all that and know the most relevant information and do that. I know we have a program here that we use for startup companies where it may not include any of the basic services, but we have a monthly subscription program basically for startup companies that say, hey, we'll meet with you regularly just to identify what you have, to keep up with that and kind of keep you on the right track going forward so that you don't miss these important things, and that we can identify things early on and protect make sure that we're protecting your interests.
Kevin, what are your thoughts on this?
My thought is that, there are a variety of online sources, and I agree with Ramon that, if you are in the space, you are continually getting the latest from the courts. I would say that there's not very much that occurs with the legislatures. The Patent Act, for example, was the first, the one that I came into and practiced under, had been initially passed in 1952. And so the next one that came along was in the aughts during the Obama administration. And so there was a lot of feeling, I suppose, for many decades that nothing needed to change in the patent area. And then when it was discussed that things needed to be changed, it was glacial. It moved very, very slowly. And there were lots of efforts by those people who benefited from the Patent Act for not changing it. So the main issue that you get is a kind of gossip. If you're in the space, and you'll have a variety of judges in your district, in your judicial district, who will issue opinions from the federal court, generally in the trademark area or the patent area, and then you'll say, "Oh, did so and so come out with something? Let me go look at that." And you would spend at the end of your day, that's what you would do. You would take a look at the opinion. Plus, you get to be, if you're a budding lawyer, get to be friends with other lawyers in your space. Go to lunch with them, talk about your practice, talk about what you do without revealing client information, of course, and you're going to learn a whole lot about what other people are facing, and you'll learn to fight the fires that they're dealing with as well.
Right. And Rick, I think you touched this topic a little bit. And I want to ask you, because we've seen there is a major shift in the IP space for last say, 5 years, and definitely after COVID, a major shift towards automation, especially towards machine learning and AI-enabled tools. So, can you suggest some tools and resources that are available for startups so that they can, manage their IP portfolio effectively, for the budding attorneys, for them to, go through these tools and maybe manage their portfolio?
So I'm not sure I understand the question completely, but I guess if we're talking about, using AI, or are we talking about just keeping up on trends with regard to AI?
So using AI and machine learning. So there are a lot of tools in the market right now available. Tools which are doing automated searching, tools which are even able to draft applications. All those things. Are there any tools available in the market where the startups can use them, to be in the game?
And again, I would caution startups or anyone from using AI as a substitute for, an experienced patent attorney to prepare a patent application for you. I haven't tried any of these resources out yet, and I'm skeptical of some of these that, say that they can use AI to prepare a patent application for you. And again, there are a lot of tools out there. First thing to probably realize with any AI tools is if they're free, you are the product, not, so, the information you're feeding into these AI tools, unless there's something very specific in there that indicates that it's, going to be kept confidential and not used for whatever purpose they want to use it for, it becomes part of their bigger database and becomes part of their system and part of their universe, so to speak. So be very cautious and very careful about putting anything in there that's client information, client confidential data, because you don't know where it's going to go from there. So Chat GPT, some of these, and again, they're good tools and good resources for other aspects of your practice. It helps me put together, blog articles, things of that nature, at least to get the ball rolling and to generate a first draft of something. But again, there's hallucinations, there's other things out there with AI. So, if you're going to use it as a tool, but don't rely on it, because you still need to be the person to fact check it and to make sure that it's actually providing accurate and relevant information. We've all heard the story about the attorney that submitted a brief to the court that used AI to draft a brief, and the AI that drafted that brief made up cases, came up with, just things that didn't exist. So it's very important to fact check these AI tools.
Yeah. Yep. Okay. Rick, sorry, Kevin, do you have any experience with these AI tools?
I absolutely agree with Rick, and it really came home to me when I was starting my international practice, and clients would send me emails telling me things in German or telling me things in Japanese or in Chinese. And then my first instinct was to take that email and then put it onto Google Translate so I could figure out what it says. And so you can't be doing that. Do not do that. That goes into a database that belongs to somebody else, is precisely what Rick is saying. And you will lose your license if you do that sort of thing. So do not use in-house licensed translation tools. Do not use what's available on the web for translation or anything like that, because you are the product, as Rick says, and you have a duty of confidentiality to your clients. You can't be breaching that by trying to figure that out. So, I learned German instead. I learned Chinese instead. And it was it's a lot easier. And I actually get to understand, a little bit more about what people are thinking, because they think in different ways when they're in different languages.
Raymond, your experience, you've worked with multinationals. Have you seen big organization using some AI tools?
Personally, haven't seen that, but I have heard of people that might consider the idea. And one additional risk of doing what these gentlemen are describing is from a patentability standpoint, if I am an entrepreneur, a startup person, and I want to draft my own, which I would never recommend that you do, and you use open source AI and you're disclosing the invention, that becomes a public disclosure that has an effect on the novelty that you need eventually in the US, but also in other jurisdictions. So don't do that. There are AI tools that you subscribe to and somehow run out of your own server. You may want to look into that, but even then, I don't trust it. Just go find yourself an attorney, an experienced patent attorney or any other attorney that would know what they're doing. Um, and yeah, so that's another watch out that I'm always thinking about.
Yeah, yeah. And I remember, I was attending one of the conferences. I think it was IP Council Cafe, and they were demonstrating one of those AI tools for searching. And the references which the tool was showing, there were few references which were not there. The tool just made up those references and just showed it in the results. So yeah, definitely something everyone needs to keep a watch on.
Those are good conferences, Arvinder. My friend
Yeah.
Sandy runs that.
Yes.
Really, really good.
Yeah. Okay. So Kevin, cost is such an important factor for any business, and but especially for startups, IP is a cost center. It's not generating any revenue directly. So are there any cost-effective strategies for startups? So that they can start using those strategies to protect their IP from the outset.
Use attorneys on flat fee arrangements to find out what the pitfalls are in your area. So, for example, if you're looking for a trademark in something, have the IP attorney do a trademark search for you before you invest the money into attempting to register. Because on the back end of the registration could be an opposition, and the opposition will cost you easily $325,000 and will destroy the company. So use attorneys early as your scouts to find out what the dangers are out there. Identifying the IP is critical too. We've already discussed it. So figure out what your legal budget is and keep your attorney to it by entering into these flat fee arrangements. Over time, they're going to add more nuance, and it'll be more than just simply scouting out mines for you. But your major cost in controlling IP is reducing your legal expense, and that means not getting yourself into litigation. Unless you are in a position with a bank account with $150,000 to $200,000, don't be alleging trademark infringement of your trademark so easily. Use cease and desist letters. Put the fear of God into the people who are abusing your rights or may not be aware of your rights, but don't jump into litigations and don't set yourself up to do so. Really, really important.
Yeah. Okay. Raymond, you must have come across various situations where cost is important, definitely in IP. Over the years, whenever there's a recession, the first cut they want to do is on the IP. What are your thoughts on that?
Oh, absolutely. And I agree with Kevin about looking for flat fee arrangements, which those are becoming more and more common with attorneys out there. Normally, if you go one of these big name firms, maybe a little bit harder to get those. And if you're a solo guy or small company, but they do exist. So it's just a matter of asking around. But also when it comes to saving money, to me, it's not about overall saving money in the entire expenditure that should be made, but rather delaying it, just delaying the inevitable. And one way to delay the inevitable is conduct some searches up front. Do not jump into conclusions that whatever it is that you've developed is ready for utility patent. Do a search. A search may cost, depending on what it is, it may be $500, could be $800. And it'll give you very useful information for the eventual patent once the patent is drafted as to how to convey the message and how to present it to the examiner to enhance the chances that you will get a patent. So do a search. Again, they're not expensive, and the attorney's probably not going to charge you that much anyway for their time to review the results. And it's money very well spent, and it may end up being a couple $1,000s. And again, that's money very well spent. And you're not filing an application right now for $10,000 to find out later on that none of it is patentable or very little of it is.
Okay, yeah. Greg, with your experience working with startups, do you suggest some such strategies for them, what they can, start from the very beginning?
Yeah, well, and I kind of second what Kevin was talking about with the flat fee arrangements. Litigation's where things can really spiral out of control quickly as far as cost goes, and no lawyer is probably going to take a litigation case on anything other than an hourly basis, because you just don't have control over where the thing is going to go. Now, but when you're talking about filing patent applications, filing trademark applications, crafting documents to protect trade secrets, those are all things that an experienced attorney really should have some good idea as to how much time is going to be invested in that, and should be able to quote you a flat fee for those things that are more of a transactional nature. So really, I concur with both of them, both Raymond and Kevin. Flat fees are really the way to go to kind of control your cost and control your expenses. And really, for until and unless you're getting into litigation, and you should never get into litigation without a big bankroll to spend. I have a former client of mine referred to patent litigation as the sport of kings, because you better be sitting on a pile of money in order to go down that road, because it's going to be expensive. But acquiring those rights, building your IP portfolio, that's something that you can typically do on a flat fee basis, and work with your patent counsel, your IP counsel, in identifying what to do first, and where to go from there, and how to grow that portfolio.
Okay, yeah. All right, thank you. Raymond, my next question is for you. You have worked with various multinationals as an in-house counsel. And when the startups are looking at a growth phase, they're looking to maybe file in certain jurisdictions outside their own. Can you share some key points which the startups should consider while seeking protection in the international markets?
One rule that is very popular with multinationals, and there's no reason why startups can't make good use of, is the PCT. Because that, at least, again, the name of the game is buying time before the inevitable, right? Before you actually have to spend big money. Buy time by filing first a provisional US application, followed within a year by a utility, and then eventually 30 months after the provisional, if you want to claim priority to that one, then file a PCT application. A year. 30 months eventually for you to file in national jurisdictions, but it's just about buying yourself time, but make good use of it. And again, companies use it all the time. Think of it as a financial option. With the PCT, you have the option later on to file applications in jurisdictions of interest, and you don't have to make the decision right now. So that's one piece of advice that I would give. Yet another thing is that's when it comes to protecting your IP, right? But there's also the defensive side of things. I have talked to people, even within big companies, that say to me, "Oh my God, I'm developing this product, but I want to make sure that I'm not infringing before they even finalize the design. I want to make sure that I'm not infringing on any patent out there anywhere in the world or in any of these jurisdictions," which is a lot of money. And my counsel has always just focus on developing your product first. See what works with the consumer, see what works technically. Once you have it finalized, then we'll cross that bridge. And there may be a way to invalidate an existing patent that you may otherwise think is blocking you, when in reality, it isn't. And if you multiply that by many times by looking at not only the US, but worldwide, then you're going to find that you're going to be blocked everywhere. So don't let that block you. Don't give too much consideration to those things until it's the right time.
Like, you want to add something on that?
Yeah, I'd like to add something on that. And I think that's a very good strategy. I think a lot of, when you're looking at making sure you don't infringe someone else's patent, it's a cost prohibitive thing, I think, for a lot of startup companies to do, because, one, going out and just doing a search for potential infringing patents, it's a bigger task than doing a patentability search, for example. And then the real heavy lifting comes in, because you've got to analyze the claims and you've really got to do a deep dive to determine, is there infringement? It's a lot more complicated and expensive proposition than a patentability search. And again, it's not really something I typically recommend to startups to go out and look for a fight. Now, clients that I have that are further on down the line and that are, maybe large, medium-sized, larger companies, I've worked with some of them where, and again, we don't do exhaustive patent searches for stuff, but they've got competitors, and their competitors are active, and their competitors are patenting things and filing applications and are constantly doing things like that. And so what I've done with some clients in that position is we'll set up kind of a watch service, if you will, for them. And, usually once a quarter, we'll check, to see, are your competitors filing patents? If they are, we'll identify it, we'll follow it, we'll track it, we'll watch it. We'll look at the claims, we'll do an analysis, and if it's something that is close enough to what the client is doing, then we do that deep dive into it and conduct an infringement or invalidity study to see, is this really something that we should be worried about, or can we invalidate that? I did this for one particular client. This is maybe 8-10 years ago. We were doing this process. We came across with a patent, and it was something that clearly we would have been infringing on, because my client was doing it 2 years before they ever applied for it, and we were able to dig up enough prior art. We put together a very comprehensive, detailed invalidity opinion for the client. And again, it was literally within 60 days of completing that invalidity opinion, we get the cease and desist letter, as did 2 or 3 other competitors in the marketplace. One of whom filed a declaratory judgment action against them in Maine. We kind of pooled our resources, and really based on that invalidity opinion that we had put together, we're able to fairly quickly and easily secure a settlement in that case that cost our client essentially nothing. So it's a good thing to watch what your competitors are doing, and if they have patents that are of concern, by all means, you should take the deep dive then, because it's going to pay off down the road. This probably saved them tens of thousands of dollars in the litigation, having done this up front, than if we had gone down the litigation trail for months or years pursuing that.
Yeah. Kevin, I want to rope you in here because with your experience as a trial attorney, what do you suggest? There obviously there would be some challenges the startups will face protecting their IP, but they would, as Rick and Ramon said, they would be very cautious to make sure that they're not infringing on anyone. So in your experience, how have you dealt with startups and organizations who are trending towards that?
Well, one of my startup clients got themselves involved in a trade secrets fight by hiring two people that were in the same industry, and those two people decided when they were leaving their employment to download information from their employer because they thought it would be used against them if they joined a competing company. That was a huge mistake on the part of those two people, and a huge mistake on the part of the startup to bring those people on. Rick is right that when you involve yourself in litigation, there's just no way to predict where it is going to end. And for that, in that instance, they stuck with those two people. One of whom, by the way, is no longer with with that startup company. But that resulted in a 2.5 year misappropriation of trade secrets case, ultimately dismissed, but it took a long time to get there. So advise your clients, if you're a budding lawyer, not to bring on litigation, not to do stupid things like take your client's confidential information. This, by the way, occurred in California, which has no restrictive covenants or whatever, but it does protect employers from people from their employees who take their trade secrets. So it is really a critical thing to avoid litigation as a startup. And when you have IP counsel that you've hired, flat fee arrangement or not, you ask that question: if I do this, what happens? What are the risks involved? What are the rewards? What are the risks? Get yourself into that habit. And if litigation ever comes up as a risk, really drill down on that, how it could happen, and what are the steps that we can take to prevent it.
Yeah, and I think one important point, we've touched, and I want to take everyone's opinion on that, is what to go for, what to patent, and what to keep it as a trade secret. And I think for startups, it becomes very important. So Raymond, why don't you start with your thoughts on how to decide what to be patented and what to keep as a trade secret?
Great question. If it is something, right, I mean, the law keeps changing, right? 10 years ago, 15 years ago, someone with a business method type improvement would have probably thought of protecting it through a patent, but that is no longer the case. Same thing with software. Software is really, really difficult. It's not impossible, but there have been some major decisions at the highest courts in this country that tell us that it's very, very difficult to get that. So you need to look at alternative ways of protecting it. And there are design patents, there are trademarks that can protect some of the logo of an interface that is produced by software. There are things you can do, but then trade secrets, that is an entire new area that again, there's a lot of litigation lately on that, and there are measures that companies need to take. And at the outset, I would say, even if you think something could eventually be patentable, treat it all as a trade secret. Until and if you file a patent application and it publishes, then obviously it isn't any longer. But at the start, I would say treat everything as a trade secret. If you consult with an attorney that knows what they're doing, they should be able to give you advice on how to compartmentalize information, then agreements in place about having to monitor the communications of your employees with the outside world, et cetera, and having those measures very well documented so that later on you can prove that everything was treated by you as a trade secret, and therefore you can treat it as such in litigation later on.
Right. Rick, your experience on, how to differentiate what to go for a patent, what to keep it as a trade secret, because we know some of the biggest organizations, they have trade secrets and they are kept in safes, lockers.
Absolutely. And I think and again, it's something that you really need to look at on a case by case basis. And it helps to, again, consult with an IP attorney that's experienced in knowing how to protect things via trade secret as opposed to by patent. But they're kind of opposites in some degree. I mean, a trade secret, is information that, you conceal from everyone. It's not publicly available. If you're patenting something, just by nature, the patent application has to have an enabling disclosure. So whatever your invention or process is, in order to patent it, you have to lay it all out there in your patent application. And then that's going to give you assuming a patent issues, you're going to have a 20-year monopoly on that. But at the end of that 20 years, it vanishes. So lots of things to take into account in deciding trade secret or patent, one of which is, what's the lifespan of this thing? And probably another thing is, how easy is this process or this thing to reverse engineer? If I put this out there, can somebody easily take it apart, reverse engineer it, and figure it out? If so, probably better off patent protection. I mean, the Coca-Cola formula is probably the best example of when to use trade secrets instead of patents, because if they had patented the Coca-Cola formula, 100+ years ago, everybody could copy it and everybody could make it right now. But instead, it's just a very closely held secret, and they've managed to keep it confidential and keep it secret all of these years, and the protection just continues. So those are really two of the primary things to look at, but there's a lot of other things as well that would be considered as to which form of protection to use.
Yeah. So Kevin, all the startups, whenever there is a new organization which comes up, there is a race for valuation. What is the worth of that particular organization? Everyone wants to be the next unicorn. Now, what do you suggest? How can intellectual property play, in the overall success for that startup and success, and maybe provide them with a greater value as an organization?
So any IP that you develop outside of trade secrets, copyrights, patents, trademarks, they are going to be able to be subject to third-party evaluation. You can have a confidential disclosure to intellectual asset managers, and they'll be able to say, well, that trademark is yielding this revenue, and you fended off this challenger, and there's this revenue associated with it. So if you've got the money to put IP into the bank, do so. Principally with trademarks. You may go on to copyright, which we haven't talked a lot about here, and patents. Patents are the key, but they require you to do a lot. When a patent hits your portfolio, you become a much more valuable company. There's almost an automatic value associated with that for any asset sale, and that is one of the key areas where people who negotiate these deals, they talk a lot about that issue. How long is remaining on the patents? What are the likely challenges out there? How much licensing revenue can we generate? It's real money, and it's, generally speaking, it comes back many times over what you spent on it, unless of course it was a really difficult situation and you got yourself into a litigation. So what I would suggest is simply spend the money on it. I just want to loop back to a little bit about what Rick was talking about. Sometimes in a situation where you're making the determination, do you want to go with a patent? Do you want to go with a trademark? Do you want to go with copyright, trade secret? Sometimes the decision is made for you. I had a situation where a guy that my client, who was German, hired in the United States as an investment, a startup investment. They spent millions of dollars, the Germans millions of dollars, developing this company in the US. And the president took what was a trade secret and it was software, and he began copying the software that he developed when the company failed and the money ran out from Germany. And he started his own new company that looked a whole lot like what the old defunct company was doing. So we sued him, and of course, we don't have a trade secret anymore. It's out there, and he's using it. It became available. So we went for copyright protection on it, and we had the documents to show that we had copyright protection on it. Copyright protection got us into federal court on an injunction, and ultimately it ended the case in a really inexpensive way for the very difficult the client who was in a very difficult position.
Yep. Okay. Right. We're coming to the end of the webinar now. There are 5 minutes left, and I want to quickly take your thoughts. I want to include everyone here to see if you have any notable case studies which you could share with our audience, especially the startups, which can they can learn from it, they do not make those mistakes. I know we've touched upon this topic a little bit during our conversation, but if you want to specifically talk about some of the case studies, it's open to all of you.
I already talked about my case studies, both of them. Go ahead, Ramon.
Yeah. Raymond?
I'll share one. There was a client, a very big client that I kept advising to avoid some of the European style drafting of applications, right? There's a lot of watch outs. There's a lot of so-called patent profanity that Rick will probably appreciate. And they used one such profanity where there was just one very short statement. They found themselves in litigation as the plaintiff over that patent that they asserted. And that one statement, and talking with the actual litigators, ultimately cost my client $35 million that they had to forego. That had that totally unnecessary line not been there, they would have been able to claim an additional $35 million in damages. And I'm not going to get into the details of why that was the case, but that was the value of that one line, not even the whole patent, but that one line. And I was able to then go back to them and say, see, I told you, don't do this. But anyway, I don't know if they learned the lesson, but so focus on quality. If you get a patent attorney, make sure that they do high quality work, and rather than just high volume type work where you may get very narrow protection and something that the minute that it hits the courts is going to be invalidated or found to be of zero value.
Right. Rick, do you have a case study which you can share with our audience?
Yeah, I can share one in particular that I can think of, and it's probably another one of those people always ask me, what's the most interesting thing you've ever patented or worked with? May or may not be the most interesting thing, but it's the one I think people can relate to. I represented a company, and this has probably been early 2000s. They came up with a fairly revolutionary timing system for these 5K, 10K running races. Prior to them getting in the market, if you ran in a 5K or 10K running race, you had this clunky device that they would strap to your ankle, and you, at the end of the race, you would have to wait in line to get it removed, or you'd have to pay them, a $25, fee for not returning it, because these devices were big and expensive, but that's what they needed to do in order to track your time in these races. This client of mine came up with a way to use very inexpensive RFID tags for the same purpose. And they tinkered around with it and came up with, their first iteration of how it worked, and finally got it to a high enough read rate that it was a viable system, and came to me, and we patented that initial tag. And they continued to kind of grow and improve and tweak it. And, probably over the course of the 8 or 10 years that I worked with them, we got maybe a dozen patents. And of course, they're out there running these races. So, we're trademarking all of the different devices that they come up with and whatnot. So, it's a good story of a company that really just kind of started working out of their garage. They were runners. They're trying to figure out a better way to do this. They came up with it. They sought my counsel fairly early on. And, we started patenting this, trademarking that. We identified what are the most valuable things to protect at what point along the line. And as they grew, we became more involved with them in growing and protecting that IP portfolio. I think it was about 6 or 8 years ago, they got bought out by Lifetime Fitness, a big company out of Minnesota. My former clients living the easy life now. He got paid very well for his company. And so one of the success stories that we've had is taking that company, guiding them along the way, watching them grow, watching them develop, and be able to then sell their company to somebody else. And again, it's primarily because, they had some tangible assets, but if you look historically, if you go back to the 1980s, most companies in the 80s were based on their tangible assets, their machines, their equipment. That's what the value in those companies were. Now that everything's digital, the value's not in those tangible assets. The value of a company is in their intangible assets. It's in their intellectual property. And that's what somebody's going to pay you for when you build this company and want to sell it to someone. It's that intangible property, that IP that's valuable. And that's, kind of what we got to get through to these startups is don't back burner this. This is important stuff. This is what's going to bring value to your company, not some of these other things. So don't kind of treat it as something that you can get to later because, maybe you can, maybe you can't. It's best to really protect those valuable assets early and as early as possible.
Thank you so much. And I think we've literally run out of time, but we do have some questions. I think I just want to pick up one to start with, and then end the webinar here. So we know that government is promoting a lot of startups. They're helping them with their protecting their IP. So are there any programs that you recommend startups should look out for from the government?
One that I'll throw out there that the patent office is running currently, and we've had several clients take advantage of this. They have a pilot program going on right now. And again, you're gonna have to be a very small company because there are certain, you have to qualify as a micro entity, which is generally under a certain threshold annual income basis. But if you're a micro entity, if you've never been named as an inventor on a patent before, and if you meet some other criteria, the USPTO will expedite your application, assuming you petition for and qualify. You can fast track your patent application. So instead of filing a non-provisional application and waiting a year, sometimes more, to get that first office action, if you qualify, if you file and are approved for this program, we're getting first office actions 60 days after filing an application. So it really is something that can take you from filing to an issued patent, which is what you need to enforce your rights much quicker than normal. That's only one resource I can think of right now.
I want to thank all the panelists here for such a wonderful, insightful discussion we had. Sagar.
Thank you so much. Thank you everyone out there. Thank for the attendees and the live audience on LinkedIn. So we are recording this webinar and we'll be putting this on our website, draftandcraft.com. You can visit our website and go to our event page, and you can have that recording within 1 or 2 days. We'll also be sharing the link on our LinkedIn and social media platforms, so you can go there and watch this insightful session there. and looking forward to meet you guys once again in August. Thank you, Rick. Thank you, Arvind. Okay. Thank you, Ramon, and thank you, Kevin, for giving your insightful experience to all attendees. Thank you so much.
Okay, thank you.
Thank you, everyone.
You're very welcome.
Thank you.
Bye-bye.
Thank
All
you.
right, take care now.